Hey there, welcome back to yet another episode in the journey of demystifying the Patents Act. A quick recap. Over the last few videos, we discussed the patent rights which are accorded to a patentee upon the grant of a patent under Section 48. We also discussed a few activities which are exempted and are not considered as infringing activities as per Section 47, 49, and 107A, the Bular provision. Now, keeping all these constraints in mind, we have identified an activity and categorized the same as an infringing activity. We have generated the claim chart. We have done the product to claim mapping or process to claim mapping to prove that such an activity is indeed an infringing activity. So what do we do now? Who do we approach? As per Section 104, one can file a suit of infringement with a district court which is designated as a commercial court or directly with High Court based on the jurisdiction. Now, the jurisdiction can be decided based on the place of residence or business of the plaintiff or based on the place of infringement where the infringement actually occurred. Now, once such a case is filed, as a common practice, the defendants usually file a counterclaim challenging the validity of the patent. Once such counterclaim is filed, the entire action gets shifted to the High Court. So far, we have discussed that there is always timeline associated with every action that we take. So what could be the timeline for filing such a suit of infringement? So as per the Limitation Act, a suit of infringement should be filed within 3 years from the date of infringement. Interesting trivia it is. Before we move ahead with the process at the district court or High Court, let's also discuss who all can file such a suit of infringement. Who all? Shouldn't it be the patentee itself? Yeah, the patentee can and should file such a suit of infringement. But remember, there are licensees also in the patent. So in case of an exclusive license, under Section 109, holder of such an exclusive license is treated as a patentee itself. In a sense, the person can institute a suit of infringement on its own, and the courts also consider him as patentee itself while granting the relief, in case a favorable judgment is passed. Similarly, in a case where a license has been granted under Section 84, the compulsory license, such a person under Section 110 can also institute a suit of infringement. But the person has to first approach the patentee, requesting him to take an action. In case the patentee refuses or neglects such a request, then the holder of such a license can institute a suit of infringement on its own. Interesting difference between the two licensees, isn't it? Another interesting point. In both these cases, if the patentee doesn't join the case as plaintiff, the patentee is added as the defendant in the case. Of course, he is not liable for any cost in case he doesn't make any appearances or doesn't participate in the case at all. Okay, so now the case is filed with an appropriate court. Like any other case, somebody needs to take the onus of either proving or refuting the merit of the case. Usually, in case of patent infringement, the burden of proof lies with the plaintiff. Now, it could be fairly straightforward to prove such an infringement in case of patented products. You need to map the feature of the product with the elements of the claim. However, in case of a patented process, using which an identical product is manufactured, there could be scenarios where the plaintiff or the patentee may not be able to identify the process used by the defendant with all the reasonable efforts that they could put, but the product is identical. In such cases, the burden of proof gets shifted on the defendants. Now, the defendant needs to prove that there is no infringement that is happening. Now, while doing all these activities for substantiating their arguments, they may be required to provide a lot of details. However, as per Section 104.2, they are not required or obliged to provide any manufacturing or commercial steps which are kept as secrets. Now, you might have noticed the scientific advisor as inserted in this particular slide. you may appreciate the fact that the patent suits are techno-legal in nature. So while going over such patent suits, the courts on their own, on request of the parties, can appoint scientific advisor to assist the court in any inquiry or opinion that the court may want from the scientific advisor. Now, such scientific advisors are appointed under section 115. So during the normal course of court proceeding, the court may come up with a judgment. And let's assume the judgment is in favor of the plaintiff. So what are the reliefs that can be awarded to the plaintiff? So as per section 108.1, the court may grant injunction wherein the defendant have to stop their infringing activities. The courts can award damages or an account of profit. Additionally, the courts can also pass a judgment whereby the infringing goods or any enabling material or system that was used for manufacturing such infringing goods to be seized, forfeited, or destroyed without any compensation to the defendant. Consider another case where a patent has already survived a revocation proceeding at IPD or HC under section 64. Accordingly, a certification of validity was provided by IPD or HC. Now, in such a case, in any future or subsequent revocation proceeding, if the patent were to survive that again, the patentee can claim the cost incurred during such a revocation proceeding. So these are the types of reliefs which are awarded to a patentee in case of a favorable judgment. But do you think all types of reliefs are awarded all the time? Not all the time. As per section 111, damages or an account of profit are not granted in case the defendants are able to prove that they were not aware of the patent or had no reasonable ground to believe existence of a patent. Now, you may recall a practice of people putting patent pending, patent applied for, or patented on their products. Such a mention can also not be used against the defendant unless a patent number is specifically mentioned on the product. Interesting defense, isn't it? Now, similarly, if a patent got lapsed for non-payment of the renewal fee, so any infringement activity conducted during the lapsed period will not entail any damages. There is another situation where a specification gets amended as per section 57. So any activity which is conducted before the publication of the controller's order allowing such an amendment will also not be considered for allowing damages or account of profit. Let's discuss another use case where a few claims of a patent gets invalidated during the course of the court proceedings, but not the claim which was infringed. In such case also, the court will only provide injunction as the relief and will not reward damages or an account of profit. Unless, of course, the patentee or the plaintiff can prove that the claims were drafted in good faith with appropriate skill set and knowledge. Upon such request, the court, on their own discretion, may grant relief in form of cost, damages, or an account of profit. So in this episode, we observed the court proceedings from the perspective of a patentee, the plaintiff, and how the judgment was pronounced in their favor, and accordingly, the types of reliefs that were awarded to the patentee. In the next episode, we will discuss the suit of infringement from the perspective of defendants, the infringers, and discuss various provisions available to them as they navigate their way through the patent protections which might be impacting their business activities. So I'll see you in the next episode. Till then, be good and take care.